Hello. This is the fourth module in the award of in real estate, and it focuses on a very important issue, um, especially pertaining to past recent history also in Malta, and and it is very important that the real estate agent or manager are aware of anti money laundering regulations and the responsibilities that this law actually um, portrays on the real estate agent and also in relation to the buyer and to the seller. And in this context, we will be going over the legislation and also um, any other issues that emanate from the law and the actually the due diligence that needs to be made in relation to the source of wealth, both of the buyer and also of the seller. And this, as the previous versions for the English version, this is a sort of voiceover of what Mr. Martin Borch has delivered in the Maltese version, and so this will provide an English version to the session. What we'll be covering, actually, we will be defining what means money laundering and terrorist financing. And then we'll go also in the PMLFT legal and regulatory framework, the role for the Financial Intelligence Analysis Unit, the FIAU. We have heard this name many times, and we've seen also how FIAU has dealt with banks and investigated banks in relation to money laundering regulations. The money laundering reporting officer, which comes out from the legislation, and of course, this is not the real estate agent, but it is related to understanding how the MLRO role also in banks when buyers will try to get loans. The types of buyers that you might encounter with differences between corporate and also individuals, and rather than you be directly involved, however, it's good to know that this type of officer exists. Reporting obligations, the risk-based approach, so we understand how to do risk assessment, the anti-money laundering and customer business risk assessment, the customer risk assessment, customer due diligence, and other obligations. So let us define money laundering. So what is money laundering? And this is written as it is one of the chapters of the Laws of Malta, chapter 373, called the prevention of money laundering. So what means money laundering? The conversion or transfer of property, knowing or suspecting that such property is derived directly or indirectly from or the proceeds of criminal activity or from any act or acts of participation in criminal activity. for the purpose, and this is very important. So here we're saying that the money, the source of money is not legitimate. And it is a result of some form of criminal activity. And why? What makes it money laundering? Until this is the money is concealed, so it is either tax evasion or it is stealing. However, it becomes money laundering when, in order to conceal or disguise the origin of the property or money, okay, the property is trying to, or the money are made in legitimate format. So in our case, the buyer is trying to conceal the origin of that money and concealing the origin of that money by using it for a legitimate purpose. The concealment or disguise of the true nature, source, location, disposition, movement, rights. So here we have, it's not only the origin, but also moving money from one place to another, okay? Rights with respect of or in or over or ownership of property, knowing or suspecting that such property derived or indirectly from criminal activity or from an act or acts of participation in criminal activity. So that money is not legitimately acquired, but or property, it could be property, physical property, like a building, but it was acquired through a criminal activity. So, for instance, somebody in a political position taking a commission out of a tender, okay? Or the person is using money which is undeclared, okay? Because the acquisition, possession, or use of property, knowing or suspecting that the same was derived or originated directly or indirectly from activity, from criminal activity, or from an act of participation in the criminal activity. So, the criminal activity is actually registered as part of it's about the acquisition, okay, and if there is a suspect, okay, or knowing that that money, so here is involving also the buyer, sorry, the buyer, or the seller, sorry, the seller. So if I know that I am going to sell a property that the money derived from is of a criminal source, then the criminal source is something that the seller will be accomplice to the buyer. Okay, so let's say, so I am going to sell an apartment, and I know that the buyer is to pay me cash 200,000 euros or 1 million euros, and practically I am aware that that money is coming from an illegitimate source. And here the seller is also accomplice with the buyer. Okay? And if the real estate agent knows also about this, so the real estate agent is also accomplice. Why? Because we know or there is a suspect. Okay, so this puts a lot of responsibility on the real estate agent of how acquisitions or selling is done, and that this is done with legitimate money. And we know today that in property there is a capping of how much money can be transacted in cash. Why? Because that is about 10,000 euros. And the reason why behind is that you make sure that as much as possible there is no criminal activity. Why? Because that money has to be already deposited in a bank. Retention without reasonable excuse of property, knowing or suspecting that the same was derived or originated directly or indirectly from an act or acts of participation in criminal activity. So here we're saying that actually you keep something in your possession whereby you know that this has come from illegitimate sources. Attempting any of the matters or activities defined in the above foregoing for sub-paragraph. So, even the attempt of trying to conceal is considered money laundering, okay? And so here it's putting a lot of responsibility on reporting, okay? So reporting becomes an important aspect. And finally, acting as an accomplice, meaning that you know about what is happening and you close an eye, okay? So this puts a lot of responsibility not only on the seller or buyer, but it also puts responsibility on the agent because the agent is the intermediary between the seller and the buyer. And if he is conscious, he is aware that there is a suspect or knows that this money is being transacted in a way to conceal the source, either because it is of criminal, when we speak of criminal, is illegitimate, okay, without, and it is concealment from taxation laws, etc. So that is money laundering. So you are doing a transaction or attempting to do a transaction with money or property that it is not coming from a source that it is declared, if we put it in a different manner. So, what is money laundering in simple terms? Method by which proceeds of a crime are made to appear legitimate, as we said, disguising the origins of illegally obtained property or money with the objective of making it look like it has been derived from a legitimate source, or enables criminals to make legitimate economic use of their criminal proceeds. So, actually, this is what we call washing of money. Okay, money laundering in popular terms is called washing. It's cleaning the money in a way that it looks legitimate. Okay, so the origin of money laundering, the term was goes back to Al Capone, who during the Prohibition in 1920 in the USA has invested the legally acquired money in laundriettes. Okay, so that's why it comes money laundering. That is, you wash the money. Okay, it is estimated that Al Capone managed to launder, so wash, okay, some $1 billion. He was never found guilty of money laundering. He was jailed for 11 years for tax evasion. Why? Because though this is where I mentioned tax evasion, because the source, until it is proven that that person has tried to use it and try to conceal the money, okay, into something legitimate, it's not money laundering. It is tax evasion, okay? I have sold a building for 1 million euros. I took them cash, okay? And practically I did not declare that cash, okay? It's like when you have a business, okay? So um, that you sell things, but you do not issue a receipt. So traditionally, the process of money laundering involves first placement, so I will place the money, then layering, so I will cover it with something which is it looks legitimate, and then integrate it in the legitimate process. So making it look normal. So what are the usual methods of placement? So breaking up amount. So instead of putting 1 million euros in the bank or in a one property, I will use that 1 million euros in 10 properties. So it becomes 100,000 for each property. Okay, so in this way, it is less traceable and it becomes more complicated. Use of monetary instruments. Okay, launderers purchase monetary instruments like money orders and travelers checks. So practically using the money to buy non-tangible money. Okay, it could be converted in Bitcoin, and we know today that there is still a lot of gray areas when it comes to digital money. Blending of funds. Money launderers often attempt to conceal the origin of criminally derived cash by mixing with legitimately generated cash. So I will put 100,000 cash, but then the rest I will pay them through the bank. And this actually will make it less suspicious. Loan repayments, repayment of legitimate loans using cash derived from commission of crime. So I have a loan of, I will take a loan of 1 million, which would be legitimate and use it for something legitimate, but then I repay it with the money, with the money laundered money. Layering loan agreements, so funds transferred from offshore accounts by the launderer and are made to appear if they are a loan made by the offshore company. So redemption of life policy. Okay, so you put a lot of money on a life policy and would get back the money more than you placed, or black salary, so in cash. Okay, so unregistered employees, etc. And the third is the integration. So the third stage is purchasing luxury assets, real estate, artwork, jewelry. So the transaction is putting it in something which is legitimate, like jewelry. Nobody tells you that it is unlawful to have jewelry or to have an apartment, but you put money in there so that, and lastly, you have investments made in businesses. Why? Because putting investments in business, which are cash, um, are actually, and you buy things, and it's that people do not any suspect. So I buy furniture for my office, I buy equipment, machinery, but I buy it in cash. Okay. So what are the consequences, okay, of money laundering? Here we're speaking from an economic and political perspective. So it is increased exposure to organized crime and corruption. Why? Because if you leave money laundering happening, then it will actually um, uh, increase the proliferation of criminal activity, okay, and the permissibility to transact in cash, and the cash is never declared, okay, as we see loss of tax revenue, okay, dampening effect on foreign investment. So people come and invest, but when these are investing with cash, that makes it look bad. Weakening of financial institutions, reputational risk of the country, and this we passed through this even in Malta when it was in the grey listing of the FTF. We'll be speaking of the FATF, and undermining the legitimate private sector. Why? Because if I'm selling and there is somebody selling and getting cash, so that is does not help um, people. So another aspect of money laundering, and this is why there is so much emphasis on money laundering, is terrorist financing. So terrorists are financed usually through money which is not legitimate, and this actually is linked with property, whereby the proceeds are used for arms or other purposes. Okay? Whoever by any means directly or indirectly collects receipts, provides, or invites another person to provide money or other property, or otherwise provides finance intending to be used, or which he has reasonable cause to suspect it may be used in full or in part for purposes of terrorist activities, or knowing that it will be contributing towards the activities, so that is considered as criminal activity, and it is financing terrorist activities. Today, through a lot of intelligence, the police forces try to catch these type of transactions in order to minimize as much as possible terrorist attacks, because these kill people, these devastate a country. We've seen this happening in many countries, and actually it will break down the economy. So in simple terms, what is terrorist financing? The process of making funds or other assets available to support, even indirectly, terrorist activities. So, and of course, if you're buying arms, which you will be using for illegitimate purposes, which are terrorist activities, you will not buy them from a shop, but you will buy them from illegitimate sources. So the proceeds, financial proceeds, will go to also illegitimate sources. Indirect support provided to terrorists may take various forms, such as financial compensation, training, propaganda, or even assistance relating to living expenses. So receiving, as we see here, training on how to make explosive weapons, traveling to and from the EU to carry out terrorist activities, financing or facilitating travel arrangements, and producing and distributing or otherwise making available publications that encourage terrorist activities. So it's not only doing an explosive, but also the propaganda towards terrorist activities. How does funding of terrorism takes place? So, legitimate activities, misuse of licit activities, criminal or illicit activities. So, these are ways of how one would link the money laundering with terrorist activities because cash is used in order to legitimize transactions. Okay, and there might be I'm buying a container which passes from one port to another with full of arms and it looks legitimate because it is declared as potatoes or tomatoes. I'm just giving an example. We need to be mindful that funding of terrorism takes place across three main established stages. So, the first one is raising of funds to main sources or activities that terrorists rely on to obtain funding. Okay, so it is the terrorists try to raise funding. Movements of funds that actually are used to to buy arms and actual use of funds. So it refers to location where the terrorist funds are used and in any other legitimate activity. So you are legitimizing the activity in order to pass money. So money laundering, what is the difference from terrorist financing? So practically what is common is that both offenses evade authorities' attention, so they are concealing something. There are obscure connections, very shady connections, and issues with audit trails. You cannot trace as much as possible the proceedings and protecting the identity of the sponsors. So, and beneficiaries of the fund. So, what is common between them is that actually the source is concealed. Whilst money laundering is funds used are derived from criminal activities, and the funds are proceeds of illegal activity, the primary purpose of laundering is to conceal their source and enable the funds to be used legally. So to put them in a legal context. Okay. On the other hand, the difference in terrorist financing, the source of terrorist funds may originate from legitimate or illegal sources. However, the funds, when they're being used, are designed to move towards a purpose, proper, a specific purpose to finance finance activities that lead to terrorism. Certain terrorist financing may be difficult to detect if funding takes forms of numerous small donations, as opposed to large sums. In fact, in money laundering, you will find most probably many large sums, but when it comes to terrorism, and this could be legitimate, as we said, that some of the funding would come from legal funds. So, what are the red flags? Indicators may be taking place is the existence of a red flag does not automatically mean that there is money laundering or financing terrorism. So, but there are criteria that can make you suspect, okay, that the financing is not correct, okay, or the transactions are not correct. So this leads to more rigorous due diligence Um, and if the subject person is not satisfied with the information, then um, one has to continue to to question, and if possible, if necessary, also file a suspicious transaction report. Recently, when it comes to something very recent, we had in a public entity a person who was actually misappropriating funds, which is very similar to money laundering. Let's put it this way. These were coming from legitimate funding of government, and the person was taking the money for herself. Okay, so it is a little bit the contrary of what usually happens when people have cash and which is concealed, and practically the that cash is then practically made legal. However, in this case, it was the contrary. She was actually then taking the funds of this entity, but then actually using it to conceal the source, okay? Using it in a money laundering way, okay? So trying to make, and those suspicious transactions were caught by the bank, okay? So when looking out for red flags, subject person should bear in mind the context and all relevant factors surrounding the parties or the transaction. It should also be noted that subject persons may have different visibility over various aspects that form part of the transaction. So here we have this is something related to real estate, and as you see, purchasers is focused more on purchasers rather than vendors, but both of them can be of suspicious nature. So the purchaser wants to buy multiple properties at once. Okay, the purchaser has or is in the process of buying multiple properties or within a relatively short time frame. So he wants to disperse the money which is not legitimate. Okay, the source of the purchaser's funds is questionable. Okay, so from where did he get the money? The purchaser is not so interested in the location or condition of the property, or even in the projected repair or refurbishment costs. So he wants to buy the property just to clear the money. As at the last minute, the purchaser introduces an unknown party or substitutes the purchasing party's name for no apparent reason. So he gets another person, a third person, from where the money is coming, okay, and in order to look that it is legitimate, he brings that third party. So it is a transaction over a transaction. Okay, so the purchaser is practically getting or buying that person, that property in order to cover up something. The purchaser is utilizing obscure or very unusual means of financing the property. So unusual means would be cash, okay, a lot of cash, or even bartering, okay, with other property, or bartering with objects, okay, which are valuables. The purchaser provides information which is vague, misleading, or difficult to verify. So he tries to deviate the source, okay, from where the money is coming. The purchaser is highly uncooperative when it comes to providing basic identification and verification information. So he's hiding also his own identity. The subject person is unable to properly identify the customer or beneficial owner who will be benefiting from this purchase. Okay, The purchaser provides false, misleading, incorrect information, which is difficult today, okay, but when it comes to corporate, this can happen. This is adverse. There is adverse media about the purchaser, so the purchaser is already under a red flag. The value of the transaction is significantly inconsistent with the occupation or financial standing of the purchaser. So the purchaser works, I don't know, or earns a miserable salary, but then he's going to buy a property of 1 million. Okay, so from where did he get the money? Unless he won the lottery. Okay, so it can happen. The purchaser has been identified or designated on sanctions list linking to terrorism. The purchaser seeking to use large amounts of cash to fund the purchase. Okay, so we mentioned the cash. The purchaser appears to be using funds or assets held by their company to finance property in their own personal name. So instead of using the company assets, they are using their own. So the company is a cover to their personal funds. Red flags on the vendor. So the vendor is not interested in obtaining a better price property. It seems that there may be an under table payment. Okay, it means that they would have handed cash in concealment, so a property is under-declared, and this is also something that might the government, when then it's declared, actually, if it's undervalued, they still need to pay the capital tax because they would the architect of the Inland Revenue would go and check and might declare it much more, and that puts a red flag on the person. The property is being sold for significantly more or significantly less than the market value. So there is something which is wrong, okay? The vendor is pressuring the purchaser in using the services of a notary of the vendor's choice. So the vendor is trying to use the notary in order to cover up certain questioning or certain issues that might be another notary would ask. The purchaser is financing the property from a loan given by the vendor, so there is a conflict of interest. The purchaser and the vendor know each other and are appearing to collude with each other. So they are always in agreement and practically they do not even challenge each other. And usually in negotiation, people do not agree. So the vendor and the purchaser are a little bit opponents. The property is being resold immediately after purchase or within a short period of time for no apparent or logical reason. The property to be sold was acquired relatively recently, and the sale entails a significant increase or decrease in price. So these are a little bit of red flags. The parties declare that the funds have already been transferred to each other. There is adverse media about the vendor, and the vendor is seeking to sell the property exclusive to persons who will pay in cash or through cryptocurrencies. So this might happen more and more because cryptocurrency is becoming very. If there is a lease, the property is being leased for significantly less than rental value. The lessee is not interested in the features or conditions of the property. The value of the lease is significantly inconsistent with the customer's profile, or the purpose of the lease does not make sense. Okay, so one would lease a property and it is very clear that that property is not being used or is going to be used for a third an ulterior purpose. Okay, we had situations in Malta where, unfortunately, I have to mention this to give an example. where a garage was leased, not because the the person who leased it knew about, maybe he did not do enough due diligence. Okay, it did not make sense that this guy had a garage in Santa Venera, and that was something that actually came up during an investigation of the journalist who was killed. Red flags during transaction. So here we have the transaction. The transaction is being carried out on behalf of minors, incapacitated persons, or other persons who appear to lack the capacity, economical or otherwise. For instance, you might have old people whereby these old people are being robbed by some of their inheritors. Okay, and they want to do it quickly so that they get the money. The parties want to complete the transaction urgently without a reasonable explanation. The notary is being requested to declare a different payment method on the contract to method actually used. These are very clear. There are unexplained or last-minute changes in the financing methods. So first it was a bank loan, and then we have cash, or a third party is going to pay for them. There is a donation or third-party payment from and to a person who is politically exposed person, PEP. We'll be speaking about this, and the transaction is aborted without the parties providing a reasonable context. So the parties are stopping the sale. Here you have two case studies. You can read them eventually. Okay, so I will not go into these. And we go to the regulatory framework. So what is the regulatory framework? You have the FATF, okay? So international standards, it's Financial Action Task Force, okay? So this is actually a monitoring board whereby they see that corruption and money is transacted in legal forms. Then you have the EU legislation and the local regulatory framework. So the FATF is actually an intergovernment body established by G7, which was held in Paris in 1989 by the ministers of its members' jurisdiction. Then the objective is actually to monitor money laundering and terrorist financing, and see that countries have the necessary legal frameworks, the necessary enforcement processes that actually show that they are not permitting money laundering and financing of terrorism. Okay, so there is an integrity of the international finances system. Here we have the directives on anti-money laundering. Actually, they push towards tougher punishments, cooperation between member states. So they are discussing now also the digital currency, so like Bitcoin, etc., because it's a big headache for legislators, and it's not always easy to monitor. And then you have the local regulatory framework, which is the laws, Chapter 373, the subsidiary legislation, prevention of money laundering, implementation procedures, which are actually through the national authority, the Financial Investigative Audit Unit, and then there are the National Interest Act when it comes especially to financing terrorism, dangerous drug ordinance, and use of cash regulations. And this was something that restrictions also in Europe, we can see it, where actually restriction to move from one country to another or to enter with from a third country more than 10,000 euros. And there are heavy fines and the money is lost. Why? Because it's taken by the government. And so here you have a little bit more in detail what the law says. It was enacted in 1994 and criminalizes and defines money laundering, actually lays down various tools to prevent and investigate money laundering, postponement order, investigation order, attachment order. You don't need to know all this in detail, so it's good to know in generic terms. So this subsidiary legislation of the main law actually set out obligations, and this is important, that subject persons are required to fulfill, and here comes a little bit also the real estate, customer due diligence measures. This is really about your job at times, and if you have suspects about proceedings of money, of how property is negotiated, I think you need to take a decision. It's true that as a real estate agent, you depend on sales, but on the other hand, do not forget we said that if you have a suspect, you have to report, okay? And it's reporting your clients, and because the vendor and the purchaser are both your clients, you are going to take money from them. So this is important that you have, though we'll speak about customer due diligence later on. Record keeping, reporting procedures. So if you work in an estate, real estate, you can discuss this with your managers and make a decision together. Internal control policies and procedures, management and communication. The PML, so the prevention of money laundering and funding terrorism regulations define subjects person as any legal or natural person. So it doesn't make a difference between corporate or individuals. Okay, so both can be subject to equally to this legislation. Subject persons are divided into sectors, so financial sector and designated non-financial businesses and professions. So relevant financial business and relevant activity. So relevant activity is auditors, external accountants, tax advisor, real estate agent, and here you come in the core, notary and other independent legal professionals, trust and company service provider, casino and gaming, trader in goods, in cash pay with cash payments of 10,000 euros plus, trader in Freeport, storing work of art of more than 1,000 euros. Relevant financial business is credit institutions, finance institutions, insurance undertaking, investment services, administration services to certain types of clients, collective investment schemes, so administration service to collective investment schemes, present person registered under Retirement Pensions Act, regulated markets, central securities depositories, safe custody services, and VFS. So it's very important here that real estate is mentioned specifically that it is relevant activity, okay? And including when acting as intermediaries in relation to letting of a movable property where the monthly rent, and here this is important, amounts to 10,000 euros or more. So a monthly rent is more than 10,000 euros a month. So, implementing procedures. So, what do you do? The law, not the law, the national authority has issued regulations to minimize this money laundering. Okay, so and practically the procedures aim at specifying situations, what you need to collect, how to do due diligence, how there you may you have good practice, etc. So the FIAU implementing procedures apply first of all to all applicable persons, but then in part two it applies to remote gaming and other financial risky activities. These procedures might be amended. It's very important because and you need to keep up to date. National Interest in Enabling Powers Act. So this is it's it's uh, it's another law that complements the money laundering law. So subject persons where there is reasonable subject, the law stipulates that they can be sanctioned, they can have sanctioned screening, freezing of assets, and reporting. Okay, and there is the Constitution speaks of the Sanctions Monitoring Board. The use of cash restrictions, these fall also under the same legislation. So there is a limit of how much one would be able to use as money. So what is the role of FIAU? The role is intelligence analysis, supervision, enforcement, management of the central agency, okay, and practically cash restriction and support. So you can go on their website and see more into detail their role. So what is, here we go a little bit in each one of them. Intelligence analysis, so processing and prioritization. So FIAU is responsible in initial handling of all incoming intelligence to identify those cases that require a more in-depth analysis and the sharing of intelligence spontaneously as necessary with domestic and foreign counterparts. Operations, so this action consists of two areas which respectively handle cases relating to suspected money laundering and cases of suspecting funding of terrorism. And finally, strategic and international cooperation. So, because activities do not happen in one country, they happen across countries. And this makes it more difficult to trace. And so, the FIU with other agencies across Europe, across Europe, they might they might actually money launder the through transactions between countries. The problem here is that there are money laundering through certain countries like the Panama, like Virgin Islands, like Dubai, and when a FIU might ask, or North Korea or Myanmar, which are blacklisted, when a FIU might ask for information, this is very difficult to obtain. Intelligence analysis, so this is actually some statistics about intelligence analysis, and as we see, the FIU has enlarged its activity, and between 2018 and 2020, practically it tripled its investigations. And that is, in a certain way, a good sign because there is enforcement. However, this is also worrying. Why? Because it means that in Malta there are big issues in relation to, maybe this is a little bit old, but to how money is procured and used. Supervision. So the role of a FIU is to have a risk team, supervision teams, quality control and coordination teams, and remediation teams. So these are the structure of a FIU in order to analyze and investigate, etc. The risk evaluation questionnaire is a yearly questionnaire sent to all subject persons. Through such questionnaire, the FIU will collect related to the subject person. This is sent to people who are of interest, of course. Okay, so like banks, like financial institutions, it will not be sent to the normal individual. Okay, and they have to do a self-assessment of their situation. Okay, so supervision. So as you see, these have increased, and between 2019 and 2020, practically 4 times as much, and that is positive because there is a will to enforcement. Okay, so practically the enforcement is determining whether the organization or the individual uh, has done suspicious activity, and if there is suspicious activity, a FIU tries to have proof, and apart from having proof, tries to actually determine with concreteness. There were problems with this because we see that they were challenged in court for fines that they have imposed on organizations. We had also a bank, if not two, that had closed because of these sanctions and also of suspicious activity. The enforcement, as we see, has increased in 2020 with administrative penalties up to 3,800,000, which is not a lot. When you see all the transactions, this is very low, most probably. The centralized bank account register is data collection and retrieval system for information on accounts identified by IBAN, safe deposit, and safe custody services. Okay, so this system is this system is helps in monitoring all the activities, and actually when you are monitoring the activities, Um, this is something that one will um, have to uh, make sure that um, money is transacted accordingly. So that is the reason why we have the centralized bank account register. Use of cash. So this is restricted um, restriction of cash, and the regulations about the restriction of cash has been imposed in order to, as much as possible, minimize the money laundering. Here, there are also in the link to guidelines by FIAU, and these guidelines will help organizations to monitor themselves actually. So the role of the money laundering reporting officer and related roles. Okay, so what is the role? The role is requires a subject person to appoint one of its officers. So subject person could be a real estate agent as MLRO. Okay, whose core functions would be to receive reports from the subject person's employees. Okay, consider these reports to determine whether knowledge or suspicion of money laundering subsists, respond promptly to any request for information made by a FAU, and report knowledge or suspicion of a person's connection. So you tell me about how this works in a real estate agent. So actually, here, the real estate agencies, I don't know if they implement this, but they should have somebody who might report certain types of transactions. Um, so in real terms, this reporting is something that one has to do in as part of the job, who can be appointed either an officer of a subject person, so you have a person dedicated for this. This in financial institutions, this is common. Okay, and also in gaming industry because they have a lot of responsibility and there is a lot of money. Sufficient seniority and command. So this person has actually um, good command of what is happening around. These are the duties, okay, of a money laundering reporting officer, and one has to report also the conflict of interest uh, reporting obligations, okay, when considering internal reports to go to FIAU, and when the MLRO has additional functions, conflict arises because independently the individual holds any other employment also results to be a beneficial owner. So the MLRO, it's very important to be an independent person. Appointment and resignation of MLRO. So here is a procedure, okay, of how this role can be appointed and also resign. And practically here, there it speaks about the designated employee, okay, and must receive the approval of MLRO, and this is appointment, and this appointed person will work with the MLRO's this direction. So the MLRO might have, and this may be very common in banks, an assistant sort of in order to also act as a MLRO. The monitoring function, so the day-to-day monitoring and implementation, the appointment of such function is not obligatory. If such function is not appointed, it means the MLRO has taken up such role. Okay, so the MLRO can have people with him or with her to develop to monitor, but this is not obligatory. General oversight function, policies and procedures, and the board may appoint one of its members with responsibility to ensure the subject person is fulfilling the MAL procedure. Registration process. So this is the registration process on the CASPAR compliance and supervision platform for risk assessment. So we pass to reporting obligations, and this might be of interest directly because, as we said, if there is suspicion, or you might also assist to certain red flags that we mentioned in the beginning, you might have an obligation of reporting. So what the regulations state. So here we have practically one regulation where it states the reporting procedures which a subject person is required to have shall provide for the appointment by the subject person. So the subject person here is your agency. If it's not your agency, it's yourself when you are a broker. Of one of the officers of sufficient seniority and command to the reporting officer. Any information or any other matter which may give rise to a knowledge or suspicion that funds, regardless of amount involved, are the proceeds of criminal activity or related to funding of terrorism, or that the person may have been or may be connected to money laundering or financing terrorism, when a subject person knows, suspects, or has reasonable grounds to suspect that funds, regardless of amounts, are the proceeds of criminal activity or related to funding of terrorism, or that a person may have been and this may be connected with money laundering or financial terrorism, that subject person shall disclose the information supported by the relevant identification and the documentation to the FIU. So, you are not required to investigate yourself, but if you have a suspicion or you've seen transactions that bring up a red flag, then you are obliged to report to FIU. And here there might be the implementing procedures. So you have to submit on the same day that the MLRO considers there is knowledge, suspicion of money laundering. Alternatively, in the shortest time possible, if case is complex, internal reports to be considered with utmost urgency, and the MLRO must be adequately supported. Now, as we said, we know that there are brokers who work on their own, so they are the MLRO themselves. But then there are people who are working within agencies, and you need to speak about what procedure do you have within your agency. Reporting procedures must have in place procedures related to both. So you should have procedures if you work within an agency, and you need to know them what you should do. Okay, I will not go into this detail because you need to refer to your agency. Internal reporting. So this is about unusual transactions. She needs to perform a review of the relationship. Such review may involve asking additional questions to the customer or request additional documentation. Of course, this is very difficult when it comes to real estate. Why? Because these people are your customers. So, what questions are you going to ask? And this we will speak in customer diligence, but um, one has to be attentive because, as the law says, you might become an accomplice. Okay? So, and if somebody is then actually, like the case I mentioned recently, where you had a public entity, most probably the agents were called also to witness or being asked by the police about the transactions, okay, whether they had suspicion, okay, because you are part of those transactions. So you need to pay attention because even if you close an eye or you say, I do not know, however, you might still be questioned. So this is where it's very tricky because this, when you are a real estate agent, is not like, uh, how do I say, in a bank you meet the officer meets the customer, but those who are doing the the filtering, the vetting at the back do not meet the customer. So actually, this is a little bit different, and it's if a customer feels that you are suspecting in him or her, that makes the relationship very difficult. So, knowledge, suspicion, and reasonable ground. So, you need to have knowledge about money laundering, and the subject person is aware or in possession of information. So, you have to have the information. It can be a suspicion that there is something in existence or reasonable ground to suspect. So this is nuanced. Either you know exactly or suspicion or reasonable ground to suspect. So you need to go back to the red flags and see that actually um, you are you are not um, um, closing too much in, your eyes because you will be in trouble afterwards. Okay, so the external are submitted by, so if there is suspicious transactions report, that's what it means, STR. It is registered on a website, and there is the Go AML portal. There are 8 types of reports: suspicious transaction report, suspicious activity report, which is different from transaction. So you think that the money is coming from a suspicious activity. Politically exposed person report. So you have somebody who is in politics. It could be members of parliament or as also members of a party. So they are not the workers of within a party, but I'm speaking here those who have high positions within a party or politically exposed person transaction report. I'm not saying you report all political people. No, there is a suspicion. Okay, so if you are dealing with a political person, you need to go to have 100 eyes. Okay, it becomes very hot. Okay, and in itself having a politically exposed person as a client or as a vendor, so as a buyer or purchaser, it needs certain attention. Terrorism financing report, terrorism financing transaction report, additional information file, so transactions, additional transactions of a report already done, and transaction report relates to pending transactions where the subject person would be refraining from carrying out the transaction. So here you have the types of report that you can find on the system. The FIU, of course, might request more information, police or and any other supervisory report. So they might need more information. So subject person section, so if you're working in the agency, it's not about you, but about the agency, retaining the business relationship or terminating the business relationship. You might have your boss telling you, stop trying to sell to this person, okay? You should not take it badly. It was your duty to report. It was your duty to question. And if the customer is classified high risk, so this it needs to be marked within the agency. Okay. And there should be monitoring because he might stop from the relationship with you, but as you know, you are many agent and he tries. This does not happen with a broker because a broker is one person. But this can happen with other people. FIU might ask you to continue to monitor, or the agency continues to monitor that person, whether he tries with other agents. As you know, you have branches, you don't know all the other agents, and from one branch, he might go to the other branch until he is flagged maybe across the branches. So this is very common in banks. Okay, they have regulations how to implement it. For instance, if you have more than 100,000 turnover, they would ask you for the source of wealth, etc. The subject person's obligation after reporting. So him, and this is where the agency comes in, they might tell you to stop the transactions or delay the transactions. Okay, so you might delay the transactions and postpone them. You tell me, but I cannot control the vendor and the purchaser. But if you are the real estate agent, you might slow down the process. You need to do it with attention because you have the convention and then the contract. And if this is happening during the convention part, you have a time limit, okay? And you need to see with the agency how to go around it. Maybe the issue is not with the purchaser, but with the vendor, or it is with the purchaser and you need to speak to the vendor. So this is not very easy to do. So here we have the number of reports that were submitted, okay? And as you see, this is mostly are the gaming industry, okay? Here is where it comes to real estate, okay? So most of them, it's not within real estate today, they are paying attention. There are very high restrictions when it comes to banking about the amount of cash. So the cash is not elevated, but it can happen. Okay, so it still went up to more than the double. So request of information. So they have 5 days. You have to respond within 5 days, and as you see, other subject persons. So it's in the middle, but most probably this was very few from the real estate. Tipping off occurs when a disclosure is made to customer third parties of the fact that there is a report. So if you're the agent and you tip the vendor or the purchaser that there is an FIU report, that is a leak. Okay. And there could be conviction of 15,000 euros fine. Okay. Imprisonment of 2 years or both. So you need to do a risk assessment. Okay. So you need to take care that you do a risk assessment, especially when you might already know that there might be risks like PAPs. Okay. So what are the notions of risk? So the two factors, which are one is horizontal and one is vertical. So what is the likelihood? What are the threats, vulnerabilities, and what is the impact? So what are the consequences? Loss of earnings, action against the company from regulator, and reputational loss of trust. So here the risk is you can calculate it, and when it's high, okay, it is needs to be reported. Here you have the levels of risk, supranational, national authority, and subject persons. Okay, so the risk assessment is done at various levels, and it might be so how you do business risk assessment. So here you have the requirements. Every subject person, and here we're speaking also of an agency, shall take appropriate steps proportionate to the nature and size of its business to identify and assess the risks of money laundering and funding terrorism. So here it's putting the responsibility on any company to do its own risk assessment, taking account risk factors, including those relating to customers, countries, and geographical areas. For instance, we as an institute receive monies from third countries because we have third country nationals as students, and that is something that one needs to see that certain delivery, that even delivery of money from certain geographical areas might be risky. Okay, so and one has to do risk assessment. In fact, with students, we pay attention. We do due diligence. Of course, they need to get a visa, and the visa would do its due diligence. But at the end of the day, even when they present the bank statements, we guide them and help them that the bank statements are transparent as much as possible. FIU implementing procedures, so starting with the methodology, reasons for considering a risk, the outcome of this risk assessment, so business risk assessment, and information sources approved by the board and must be updated in case of new threats, changes to business, material changes to external environment, and it can be reviewed annually. Inherent risk versus residual risk. So inherent risk is one is exposed to prior to adopting and applying measures, policies, and controls. to mitigate the risk. Whilst residual risk is the risk left after the so what can you do is actually mitigate the mitigating measures, so control the level of risk. What are risk factors? The customer, an interface, the geography, risk itself, product severe, and transaction. So why we are speaking here about real estate? Because real estate is in itself a high risk. Why? Because you are transacting hundreds thousands of money and the impact can be high. We're seeing also now in news about people who are doing fake, using fake posts, for instance, to acquire money. So risk factors are the customers, because there is high risk of cash-intensive businesses, business associated with higher risk of corruption, like arms trade, mining industry, activities associated with a higher risk of money laundering, visual assets like Bitcoin, activities conducted through opaque and complex structures. So it is a company and a company and a person and another person, and you have too many parties to try to control. Customers applying for the passport, okay, so the citizenship, the investment scheme, and PAPs, political people. Low risk are companies listed on a regulated market and are subject to enforceable disclosure requirements, and entities carry out relevant financial business and equivalent activities subject to equivalent AML obligations as those applicable in Malta. So when a company is audited, when a company is transparent, so product, services, and transactions. So use high risk is using cash, non-bank loans, third-party funds, use of virtual financial assets, unusual funding methods, and high value. And low risk is the purpose of the transaction is evident, establishment of residence. The value of the property is modest and according to the market, and consideration of the property is commensurate with the average income of the purchaser's jobs. So the purchasers are afford that the loan payment or that property, financing through bank loan, gradual repayment, because this is very safe and there is the due diligence of the bank. Delivery channels. So the customer, whether buying, selling, or renting, is being represented by somebody else, so that is high. And the customer is interacting on and on face-to-face basis. So these are actually a little bit high. Here you have geographical countries on the European list of third countries having strategic deficiencies in their AML, countries identified by other creditable sources as having serious deficiencies, countries subject to sanctions, embargoes, countries identified by credible sources as providing funding or support to terrorists, countries identified as having significant levels of corruption, okay, countries that have shown a lack of willingness to comply with international tax transparency rules, and countries that fail to implement beneficial ownership transparency. So international sanctions were on place, and you can go to this page and you go in more detail. And then there is non-retributive jurisdictions like listed under the FATF, okay, high risk jurisdictions, and there is a high increased monitoring considered as automatically high risk. EU identifies third countries that have strategic deficiencies and regimes, like for instance, if I have a student from Nigeria, they are questioned even if everything is according to rules, etc. Here you have the FATF list according to 25. As you see, jurisdictions subject to call for action and jurisdictions under increased monitoring. Unfortunately, in 2021, Malta was what we call grey listing. Okay. Non-reputable versus high-risk jurisdictions, level of transparency and rule of law, corruption, war-torn countries where there is war, there is a probability of corruption, significant levels of types of crimes, significant level of terror threats, manual mutual evaluation, and other notable sources. So we'll towards the end. Then you have the customer risk assessment. Okay, so here one has to question the vendors and the purchasers. Okay, so the reputation um, is the person in court, criminal activity, etc. Even if it's not related to money, but you have drugs, you have maybe issues with selling property in the past, etc., or buying property, and the nature and behavior. So, if the customer is reluctant, making it difficult for you or the notary to give details, the structure involved bearer shares, for instance, money coming from Switzerland, because Switzerland still have bearer accounts. Is the customer requesting unnecessary or unreasonable levels of secrecy? So this is something that one. So categorization of risk factors and weighing and rating of risk factors. So this is how we carry a risk assessment of a customer. And here you have like a scoring grid, okay, type of customer, um, product service, interface, and geographical connection. So as you see, EU member or domestic is low, face to face. So it's not a question. You have the vendor and the customer physically meeting, products with very limited transaction or deposits or thresholds, or individual pensioners, so people who have moderate income. Okay. Something interesting is some non-profit organizations in high, non-reputable or high-risk jurisdictions. So even NGOs might be considered as high risk. In Malta, NGOs have annual returns, have to declare income and expenditure, etc., to the authority. So you have this from very high to low. So the high, very high, you question, and actually here it's suggested that you do not establish a relationship, or in high that do not allow the transaction until the risk is reduced. Medium may go ahead, but preferably reduce the risk, and in low it is actually negligent the risk, and you can go ahead. So customer due diligence. So let us speak a little bit about the customer due diligence. So the process, identification and verification. So 4 steps, verification of the customer, identification and verification of the beneficial owner, purpose and intended nature of the business relationship, ongoing and monitoring of the relationship. So, who is considered a customer? In your case, it's can be a business, it can be a person, and the person can be a vendor or and also the company. It can be a vendor or a natural person. Okay, so you need to take in consideration when we speak of legal person, we're speaking of a company, and the natural person, we're speaking of an individual or a couple, because you might have couples who are buying. Um, so a business relationship must have 3 elements. One of the persons involved in a subject person, so they are part of a company. Okay, relationship must be of a business, professional, and commercial nature. So it's about the selling or the buying, and the relationship must subsist for a period of time. So in your case, it is until the sale uh, is completed. In case of a business relationship, the subject person must assess and obtain information on the purpose and intended nature of the business relationship, and in your case would be selling or buying. Occasional transaction and a transaction or service other than a transaction or service carried out in the exercise of an established business relationship, or such will include the intermediation services in relation to letting of immovable property where monthly rent amounts to 10K plus. So this is an occasional transaction, and so less transactions, less of value would not fall under this uh, concept of due diligence. Who is the beneficial owner? UBO, ultimate beneficial owner, and a natural person who ultimately own or control the customer on whose behalf a transaction or activity is concluded. So you are actually concluding the process. The UBO, in case of a body corporate, so there is direct ownership or indirect ownership. Okay, so or control of the body corporate or body of persons. So here we're speaking of businesses who have shares, okay, or indirect ownership when it comes to less than 25% of shares, okay, and um, oh, sorry, it's the contrary. So this is actually if you have a company is actually is the ultimate beneficial owner. The natural persons holding in the position of senior managing official if after having exhausted all possible means, no beneficial owner as defined under paragraphs 1 and 2 above is identified. So you need to identify, and this is very important, especially if a company is with shares and not shares, here you have an example. So company A is made up of company B and C and one person. And then the company C is made up of person 3, 4, and 2. And company B is that of 100% of person 2. So we are actually dealing with companies. This can become very complex. In this case, it's usually properties are not of small value. So this carries more responsibility and it carries more due diligence. So transparency is very, very important because you're dealing with a lot of people here. Okay? And when dealing with a lot of people, these make things more complex and and the complexity might increase if you have people out of Malta in the companies involved, if you have people coming from third country nationals, third countries out of the EU. So when you have a couple who have a job, a normal job, and they're going to buy a property, that is very easy when it comes to due diligence. But when you have these type of companies that shareholders are in multiple companies, and then like the person too, he has, and they are then grouped in under company A. So that is a lot of complications when it comes to either the selling part or even the buying part, because so and here you have another example where it makes it more complex. So you have a trust, which person 4 is also coming to company Z. So this is actually you need to make due diligence on every situation, and natural persons required to be identified as beneficial owners. So the company might not be, for instance, at the moment, we're assisting to a sale of bank. And when you have a sale of bank, we're speaking of a huge number of millions. So, okay, this is not real estate. It's a business to business. However, there is a lot of due diligence. As we know, in this case, we have a lot approval from the European Central Bank and the Central Bank of Malta and MFSA. So you have a lot of authorities involved that one has to get their approval, and this makes a lot of complex issues when it comes to due diligence. So this is another situation where you have persons more involved in the company. So in the ultimate benefit, the UBO, ultimate beneficiary owner, in case of trust, then you have the settlers, the trustee, the protector, the beneficiaries, and any other natural person exercising control over the trust. And in foundations, in case of foundations, you have the similar arrangements. So you can check about the beneficial owners in MBR, Malta Business Registry. Usually this is open to the public, but you can get more information about the individuals. Identification process, the natural person, so official name, date of birth, permanent residential address, high risk, official full name, date of birth, permanent residential address, place of birth, identity, ID card, and nationality. So what you need to ask when you have identified that in case of a company that is already in a certain way high risk. So verification of a natural person, identity card, passport, residency card, driving license. In the case of body corporate, official full name, registration number, date of registration of incorporation, registered address, identify all current directors, identify all beneficial owners. So you might have directors, but then there are beneficial owners within that company. Certificate of registration, company registry confirming on MBR, most recent merger and acquisitions, if there are, taking reasonable measures to verify the identity of the body corporate and understand the company's ownership and control structure. As I was saying, this is very important because the money that is going to be transacted either is coming from many people, even if finally, let's say, a company is buying a property. If it's buying a property, the transaction will be one, but the money from where it's coming, okay? If we have 30 people involved in this transaction that are being represented by that company and represented through different companies under the cap of that company. So it's very important to actually get the idea of who are the beneficial owners. Okay, a structure chart and explanation of ownership and control, and conduct independent research to verify the information presented. Trustee of a trust, full name of the trust, purpose and nature, because even the nature of why a trust is founded might be suspicious in itself. Country of establishment, if it's in Malta is one thing, if it's in the Virgin Islands is another thing. Okay, so trusted details and protected details, if any. The trust deed or authenticated trust deed extract. So you do not stay on the belief that person, but you need to see also documentation to verify, because what counts is the documentation. Okay, and if need be, you go on the trustee and do also verifications on the trustee if there are screening obligations. So there are sanction lists. You check sanction list, those companies which are blacklisted, PAPs, politically exposed people, adverse media, and freezing orders. Maybe there are court orders, as we've heard these last years, where big assets are being withheld. In fact, this is something also that banks do, the source of wealth, from where people are earning money, from where they generate the total net worth of the customer, and from where it's generated, and the source of funds. Okay, the activity, event, business, or occupation or employment of that person or of that. You can have a millionaire in front of you, like Elon Musk, and practically the source of wealth, supposedly, is coming from Tesla and the other companies that I think there was an article where he was net worth of 1 trillion, I think, 1 trillion, I think. So, or over 1 trillion. And because the shares increased, and but he's not the ultimate beneficial owner. There are other beneficial owners in the company that, of course, are. And if Elon Musk is going to buy Twitter, he bought Twitter and became X. So it is, one has to see the source of funds. Ongoing monitoring of the business. So in case of business relationships, one, in your case, it's due diligence and But if time has passed, you need to update yourself. It's not something that you do once, but if 2 years passed, or this client came 2020 and then he came back in 2023, you need to update your due diligence. Okay, so simplified due diligence, standard due diligence, enhanced due diligence. So this is the process, and here is actually the customer due diligence, which is simplified, and what you need to have actually to build a business relationship. Enhanced is going into more detail. Of course, if it's PAP, the customer is in your case, there are lists, in your case, mostly is PAP or transactions that are unusually large. 1 million, 2 million, 3 million, 10 million. Okay. If there are issues with the customer on FIAU, okay, so and if the customer, especially corporate body, identifies several tasks, several activities of high risk. So here you have about politically exposed persons. This might you encounter, okay? So in the Gazette list, you will find the list. So here you have the list of positions that are considered as politically and their immediate family members and persons known to be close associates of the PEP, that is like doing business with them. So the last part, other obligations. So record keeping, it's important. It's important that you keep records because if or the agency keeps records, and they have to be filed up at least for 5 years. They could be digital or physical. And record keeping, if you have an FIAU investigation, they would need to see records. Employee awareness. All employees should be made aware of due diligence. So you should have till now been aware of the due diligence procedures, internal reporting procedures, and how you deal within your agency. And if you're a broker, you need to be aware of these and be aware what to do. Vetting of employees should undergo due diligence because of employment history. You might have colleagues that have been with other agents. It's not your job to vet at the end of the day, but if you're a manager, yes, this is the job to vet and also ask for recent police conducts. And here we come to an end of this module. I hope this will be useful. Maybe it has been a little bit heavy because it's about regulation, and hopefully you will pass the multiple choice questions. Thank you.